The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Just please be seated and wait just one moment, please. We're down a justice. Justice Oxley, we apologize. Thank you, everyone. We are now here in the matter of MidWestOne versus Heartland Co-op. MidWestOne is represented by Matthew Preston, and Heartland Co-op is represented by John Moorlach. Mr. Moorlach, you may begin.
Thank you, Your Honor. May it please the court. My name is John Moorlach, and I, from Whitfield and Eddy here in Des Moines, I represent Heartland Co-op in this matter, along with my co-counsel, Peter Chalik, is at table. Also with me today, may I introduce the CEO and General Manager for Heartland Co-op, Tom Hauschel, in the front row, as well as Heartland Co-op's CFO, Brian Bailey, who is with us today. This case arises out of a dispute between Heartland Co-op, which operates as part of its business grain warehouses across the state of Iowa, and MidWestOne Bank, over the costs of drying and storing grain of Heartland Co-op's member and MidWestOne Bank's borrower, Mr. Harker. In many respects, the transaction and the sales are very typical of the tens of thousands of grain sales that happen across Iowa over the year. A farmer or a grain producer, I may use those terms interchangeably, harvests their corn and has a few options. They can store the corn and dry it in their own private facility. They may have a direct contractual relationship with a buyer, which they just ship the corn to that buyer, and that buyer has their own facility. Or, as in most cases, that grain producer stores their grain at a local warehouse that is registered and licensed under the laws of the state of Iowa, as in this case. And as is also normal in most of these cases, grain producers and farmers operate under and with operational loans and are also what are known as input loans, nitrogen seed loans from lenders. In this case, MidWestOne Bank is the lender for Mr. Harker, the member of Heartland Co-op, the grain producer in this case. So, as part of that loan agreement, the bank, as in this case, takes a first priority lien position on any crop and crop proceeds that flow from the crop year in which the operational loan was in service. What we have provided to the district court through affidavits, and what this court has also read in amicus briefs by the Iowa Agricultural Legal Foundation and the Iowa Institute for Cooperatives, is that at the time of a grain sale, and a grain sale is triggered usually by the grain producer analyzing market conditions and their own business strategy, and normally the loan documents authorize that borrower to make that decisions, calls up or notifies the grain warehouse that on that day or the following day or that week, the grain producer would like to market or sell the corn. At that point, the warehouse buys the corn, and then, subject to a buyer's notice provided by the lender, the warehouse then sends a check to the lender and to the farmer both, if everything is running smoothly. And from that, however, is offset the necessary costs for the drying and the storage of the grain. And as the record showed in the district court, and as the court has read in our briefing, drying is absolutely necessary for the marketability of the grain. The grain is dropped off, it's commingled with other grain.
Let me just ask kind of a mechanical question.
Sure.
All right. So your client, did they issue a joint check
Yes.
to the bank and to the farmer?
And to the farmer, yes.
And at that time, did they issue a receipt that showed the deduction for the drying and the storage?
In the industry, it's called a settlement sheet, and that is provided with absolutely every sale from Heartland Co-op, especially in this case.
So if the bank read the settlement sheet, they would have been on notice of these charges?
They would have been that would be one way they would be on notice of those charges. We have provided evidence in the district court that the bank and any lender in Iowa would be on notice of those charges because for at least 40 years, those charges have been offset for before the proceeds have been sent on to the lender. Now,
Wasn't the evidence in this case that the settlement sheets were not provided in this situation until the time that the bank actually filed the lawsuit?
No, settlement sheets in this case were provided along with the sales to Mr. Harker. What the bank is contending is that they didn't learn about these settlement sheets until later. I believe.
So the settlement sheet goes to the producer, not to the bank?
Yes, right.
And the producer has to sign the check and remit it to the bank?
Yes.
But not necessarily pass the settlement sheet along?
Right. And so our argument for Heartland is that under the UCC, a lender is presumed to know what's happening to its collateral, and that's where we get to the two bases for the appeal that we make today.
One of the arguments the bank makes is you could have perfected a warehouse lien, but you didn't do that. What additional steps would have been necessary to do that, to perfect a warehouse lien?
Well, there would have needed to be a warehouse receipt, express warehouse receipt between Mr. Harker and the bank, or a security agreement. That security agreement would have been perfected. It's a possessory lien, and so the only way to enforce the lien is actually to hold up the sale, express written notice to the bank, and you can imagine when I think, and this may not be in the record, but I've talked to my client, if you're talking about tens of thousands of sales by just one grain warehouse across the state, that is just not workable. And so the industry, ag businesses, as well as lenders and warehouses, have come up with this system in which other antecedent debt isn't paid for from the grain sales. I mean, co-ops and other agribusinesses provide all kinds of other products. Even I picked up dog food at the local co-op. That's not taken care of out of the grain sale proceeds. The only thing that's taken care of out of the grain sale proceeds are the necessary costs to make the grain marketable.
And what provision of the UCC specifically would allow this industry custom and practice to trump the perfected security interest?
Well, we rely on case law, and then we rely on the introductory paragraph to the UCC, in which the UCC allows for. The UCC is not meant to be a regime that clogs up business, but allows business and recognizes businesses' practices. And
I'm asking you, what specific provision in the UCC would you point to that would allow custom to take priority over a perfected security interest under Article 9?
There isn't one under Article 9. What we rely on is there are Article 7 liens that are allowed, the kind of possessory liens that we've talked about. There is, however, and we would argue that the warehouse statute is not actually a grain warehouse statute. That would be an adequate remedy at law. Both the bank and the amicus writer on its behalf raises that question.
Let's pursue that a little further. It's clear, I think, that the bank had a perfected security interest in all the crop.
Yes.
Okay. And then the crop is delivered to the grain warehouse, but the security interest attaches to all the grain.
Yes.
What in fact kind of happens is that some of that grain is used to pay for drying and storage.
Yes.
Well, so the UCC, provisions of the UCC Article 9 ordinarily would give security interest in the entire crop and in that fraction that's used to pay for storage of grain. So help us how you overcome that perfected.
And that's where we hopefully and helpfully point the court to the Colorado Supreme Court decision, 9th District Credit Association versus Ed Duggan. I'll just call it the Duggan case, in which I think provides a roadmap for this court and any court to analyze whether an unjust enrichment claim, which is what we bring to this court on appeal, can, in other words, upset the Article 9 priority when that secured lender collateral has been subject to the benefit provided by a third party. And what the Duggan case stands for is that it's a narrow exception. By and large, a perfected secured interest will be protected against any kind of claims for maintaining or improving its collateral, except in circumstances in which there's a relationship.
Let me interrupt with a question. I'm concerned, in following up on Justice McDonald's question and Justice Appel's. UCC, we have a statutory regime that provides predictability and certainty in these business relationships, and I have a hard time with recognizing a common law unjust enrichment claim when there's a warehouse statute, however cumbersome, on point. Does that statute sort of occupy the field? Or if you don't like the warehouse statute, isn't the remedy to attempt to amend it to clarify it as was attempted in the last session?
Well, certainly it would be helpful if there was an actual grain warehouse statute in the state of Iowa, without question. The Duggan case stands for the proposition that weighs the equity of an unjust enrichment in which a benefit has been conveyed to the lender at the expense of the third party, and it would be otherwise unjust for that lender to accept that benefit without some compensation. And then you look at the circumstances of that case, the relationship, the acquiescence, the knowledge of the lender that kind of services, those kinds of services would be required, and it would be unfair to allow the bank to hide behind.
But even under Duggan, isn't the first part of that test that the secured creditor needs to have initiated or encouraged the transaction?
And here we would argue that under the facts of the case, and the relief we seek here is simply that the case be remanded back to the district court, recognizing that an unjust enrichment claim can be had, and the factors and the evidence can be presented to the court to understand that. But we would argue here that under the circumstances of the case, that in fact the bank did and had to encourage Mr. Harker to market his grain through the warehouse.
I take your point. I understand your point. Somebody had to store and dry the grain. But still, normally in unjust enrichment, you have sort of a deserving party against an undeserving party. It seems to me you have two parties here that are, one of them is going to end up short. The bank is undersecured, and your client performed services that added to the value of the collateral. So, that strikes me as not the normal scenario for unjust enrichment.
One, this is not a normal case. It's the first case of impression in front of this court that raises these kinds of facts and legal issues. But I would argue that in fact the bank would not be held up short. An image I've used with friends is Mr. Harker can't simply back up his truck and dump the bank's collateral in the bank's parking lot. The bank is not licensed to do that. The bank,
Mr. Moorlach, so if you follow that theory all the way through, I assume that it's your position that if there were an agreement between the producer and Heartland, that the producer would pay. Right? It's contrary to industry custom that the producer would pay rather than having it being withheld from the proceeds. Mm-hmm. That Heartland would still, and the producer didn't pay, that Heartland would still be able to pursue an unjust enrichment claim against the lender, right? I mean, it's still the same enrichment, and they would just be able to file a standalone lawsuit for unjust enrichment against a bank because Harker breached his agreement to pay for grain drying services?
I suppose, but at bottom, the Supreme Court of Iowa has always, I believe, been a very practical court. And the industry has decided over the course of decades about how to pay for these drying and storage costs. And I wish we had. There is a grain warehouse statute in the bankruptcy code, and I don't believe I put that in the brief. I just wanted to, for the record, cite to 11 U.S.C. 557.
Can I go back to that example a little bit? So is it your position that any time a piece of collateral is improved and that would potentially benefit a lender, that the lender is unjustly enriched if the person doesn't pay for it?
Absolutely not, and I don't think that's the holding of the Duggan case at all. I believe I've got 5 seconds. Thank you very much.
Thank you. Mr. Preston?
May it please the court, counsel. My name is Matt Preston. I'm with the Brady Preston Grunland Law Firm in Cedar Rapids, and I'm here representing the Appellee MidWestOne Bank. I'm appearing today with my co-counsel Ray Terpstra and Kara Roberts of my office. I'm going to pick up with the last question from Justice McDonald, and the situation that was posed as the question is not even a hypothetical here. In fact, the arrangement per the security agreement does in fact provide that the Harkers must be and remain solely responsible to pay for the proper raising, drying, and storage of the crops. The security agreement has a care and maintenance provision for the crops that provides that they will be grown, harvested, preserved, and stored properly. That means drying. It has a provision related to the transfer and sale that says that the Harkers will do nothing that causes a charge or a lien against those crops. What that means, read in tandem, is that in fact the security agreement does represent a contractual agreement whereby the Harkers agreed relative to the bank that at the Harkers' sole expense they would ensure that this crop was dried and stored. Now, if we compare how that fits into unjust enrichment and the 3 prongs of unjust enrichment, the first one is that there is a benefit to the defendant, that it was at the expense of the plaintiff here, they're sort of somewhat confusing, but at the expense of Heartland, and finally that it would be unjust in this case for MidWestOne to retain that. So if we look at the security agreement as it relates to the first prong, that is, was there a benefit conferred to the bank there, by virtue of Heartland's act of drying and storing? There was not, because we have to first look at the legal right of the bank relative to the Harkers. Before that grain ever came in the doors of Heartland, the legal right that the bank had was a legal interest in grain that had been harvested, dried, and stored solely at the Harkers' expense.
But, I mean, all right, and so if the farmer had paid for the drying, then there would still be less. There would be less money to pay you back. So I mean, I recognize your point. Let me turn to the same issue I was asking Mr. Moorlach about, and that is, I mean, you make a point about this warehouse lien being really the remedy that's set up in the code to protect the elevator that is the one they should have availed themselves of. Right. My law school didn't teach Article 7, so what would they have to have? What would they have to have done to perfect a warehouse lien that they didn't do?
It is a little bit of an esoteric provision. I agree with that. As it relates specifically here, the mere issuance of a warehouse lien in and of itself would not have been sufficient to allow them, and this is going to be governed under 554.7209. That's the operative section. So the way in which that works is that first there has to be an issuance of the lien of warehouse. That does not, however, in and of itself allow the warehouser, Heartland here, to jump ahead of a previously perfected security interest, which MidWestOne had accomplished by virtue of its earlier UCC1. What has to happen, given the nature of the possessory interest here, is that there has to also be a communication between the warehouse, that is Heartland, and the senior creditor, that is MidWestOne, whereby the senior creditor essentially accedes to the nature of the warehouse lien. Unlike what has been postulated here by Heartland, however, that is not a cumbersome task that has to happen at the 11th hour, thereby holding up the sale. That can happen at the outset. From the moment that the Harkers ask Heartland to take in grain, in which Heartland already knows there's a previously perfected UCC1, Heartland at that time can go through the necessary steps of issuing the lien of warehouse and having the requisite communication and consent from MidWestOne at that time, which would then allow Heartland to know that they will have the requisite lien in that particular crop. So that's a process. It requires communication.
Is that a common practice?
Well, according to Heartland, it's not, but it's certainly the proper practice. I think what is most likely a common practice is for co-ops, as with any other business, they have to conduct themselves in a manner that's an appropriate business, and that is if they are going to deal with a customer such as a producer, the co-op needs to take steps to satisfy itself that it's going to be paid in that. That can consist of either ensuring that it's dealing with a solvent producer that it's familiar with and that it's confident has sufficient assets to pay them, or if it has any doubt about that, it has available this warehouse lien process to go through, both of which would require either communication directly with the producer or communication with the senior credit holder.
Mr. Moorlach made a statement that for decades there's been this type of arrangement between a lender and a grain dryer. Do you agree with that?
I don't think that we necessarily have visibility to know exactly what those arrangements are.
Where it's taken off the top and you get what's left. Do you agree with him that for decades that's kind of been a practice?
I think, Your Honor, I think we have to accept what the co-op associations are saying, which has been their practice.
I'm asking from the perspective of the banks.
I don't know from the perspective of the banks what degree of familiarity they have with regard to this practice from co-ops. I would submit that it is not, however, even if that has been a practice, that it is not a practice that represents an exception to the requirements of Article 9, but it represents precisely that type of practice where Article 9 is meant to rein it in. That to the extent that there has been a practice of co-ops secretly taking proceeds, notwithstanding the co-op's awareness of the existence of a previously perfected security interest.
Well, I'm not. One of the questions, the reason I'm asking this is one of the issues also is the statute of limitations. I mean, you have some pretty old claims that are being out there, which leads me to wonder, has that been the practice? I mean, some of these will depend on the court's ruling of statute of limitations and whether or not the discovery rule applies.
Yes, Your Honor.
That's what I'm getting at.
Okay, so let me take that in two parts then. First, to finish up with regard to the specifics in this case as to industry practice and how it may relate to Article 9. There are two factual pieces of information that the district court has that compile the entire record before this court, and that is the affidavits submitted by the producers, by Heartland here, only provide that Heartland communicated to the Harkers the deductions that Heartland was making. Certainly, if Heartland had any information that there had been any communication directly with the co-op to the bank to apprise the bank of those deductions, those would have been in the affidavits. The absence represents, I would suggest, an admission of the absence of such direct communication between Heartland and the bank. Second, the affidavit.
Could it also be an admission that the bank is aware of where their collateral is and what they're up to?
Well, these are affidavits from Heartland.
Right, but my point is, I didn't see anything. I'm just saying, couldn't the same be true for you or for the bank's silence and not doing anything until now? Couldn't that also be perceived as an admission that they were aware of their collateral and paying attention to its whereabouts?
There again, that brings me to the second point that I was going to raise, and that is the only factual information that takes us beyond speculation is the affidavit from Mr. Amthauer, who managed this credit on behalf of the bank, who specifically said that he would be the individual on behalf of the bank who would have information if those deductions were being made, and that he did not have information. So the only information in front of the district court was an affidavit from the individual who would represent the knowledge of the bank, who specifically said that the bank did not have that knowledge. So we don't have
following up on the chief's question. I mean, it strikes me that a bank, usually pretty sophisticated, if they're just getting a check endorsed by the farmer without any backup for how many bushels and all the other information that's on the settlement statement, without the settlement statement itself, wouldn't they normally ask for that information from the farmer?
Well, I think here again, what's important is that the bank has utilized the steps in advance to ensure that both the farmer and any of the 9 parties in this case that the Harkers were entitled to sell to were familiar with the bank's interest, were familiar that no deductions could be made from that collateral. And so the bank had taken the steps under Article 9 to protect its interest. It had operated within the framework of the statute, and therefore I don't think there's a suggestion that that it would be normal or incumbent upon the bank to have requested something outside of Article 9 or to have presumed that the co-op would violate the bank's security interest.
But it has a substantial lending relationship with a farmer. It just gets a check by itself in the mail. It doesn't say, well, give me the backup for the check. I mean, how much grain did you sell? What price did you get? And what deductions were made? I mean, that just seems like maybe not a prudent business practice. And it could be pertinent to the statute of limitations because maybe it's pertinent to what the Iowa legislature had in mind, that you should run the statute strictly from the date of sale and then put the burden on the bank in this case to follow up if it doesn't get all the information it needs at the time of sale.
Let me use that as an opportunity then to move to that specific issue. And let's look at the 2 sections that are applicable here. We've got 614.1 subsection 4, which would be the 5-year limitation. And then we have subsection 10, which would be the 2-year limitation. Obviously, the district court had applied the 2-year limitation, but then ameliorated it by virtue of the discovery rule. Heartland continues to argue for the 2-year limitation. I think if we compare the language of subsection 4 and subsection 10, we get important insight as to what the legislative intent is. Subsection 4 has very broad language. For example, for actions on an unwritten contract, it reads those founded on unwritten contracts within 5 years. There's no limiting or qualifying language. Same applies for those brought for injuries to property within 5 years. Now let's juxtapose that to the limiting and qualifying language.
Could we complete your reading of subsection 4 that ends with except as provided by subsections 8 and 10?
Right.
And then 10 seems to be the specific one, specific to secured interest in farm products that runs very clearly from the date of sale. Why wouldn't subsection 10 control?
Subsection 10 certainly has to be reviewed here, Your Honor. However, the comparison of those is that subsection 10 has important language. It doesn't use simply those founded on an interest in a security interest of the creditor. It goes on and specifically says 2 years, and then it has limiting qualifying language that we don't find in subsection 4, which is within 2 years after the date of sale of the farm products against the secured interest of the creditor. That language has meaning. That means that the sale itself, in order to trigger the shorter time period, it has to be that the sale itself is the thing that represents the cause of action. Now, if we look at the security interest here, for example, there was a provision that specifically told the Harkers that they would suffer a penalty if they sold the product to a party other than one of the 9 that was listed. So the concept of a sale against interest is not an academic thing, it is a specific act. And following up on Justice Mansfield's question, the reason why that's important is because we do have familiarity with the items in which we have an interest. We have a familiarity as to the parties to whom that may be sold. We know where that money is coming from, and therefore the legislature has presumed that we as the senior credit holder will have familiarity with and become promptly aware of a sale that is against our interest.
I want to go back to that question that I was asking you about the decades practice. Your agreement, you said at the beginning of your discussion, the security agreement has a care and maintenance agreement for the crops that will be grown and stored properly, including drying. I used to do tax returns for farmers, and I never once saw in a Schedule F where grain proceeds were acknowledged and there weren't a whole heck of a lot of expenses that went along with it.
Right.
So did you do a separate loan for them to pay for the drying? Did you really expect the farmers to pay for this drying in something other than the sale of the proceeds? And you mentioned yourself, they're required to have the drying. So I'm just trying to follow the logic here.
The distinction is whether the resulting, whatever those costs are, the distinction is can those costs, per the security agreement, be derived from the secured product itself. The security agreement's provision that says you, producer, will ensure that this is dried and stored, for example, and you will do so in a way that does not result in a charge against the grain. That represents an explicit contractual agreement that the producer will remain independently obligated to pay for that and that it will not result in a charge against the grain. That becomes really important because when we put the world on notice of that relationship, including Heartland, Heartland knows before that grain comes in that Heartland cannot look to the grain to satisfy its costs, but must look directly to the Harkers to satisfy those costs.
I'm wondering, so let's say now we have a chilling effect with farmers allowing that to happen with the grain company. And suppose a farmer just can't make ends meet. So you're going to get some moldy grain. How's that going to follow through with their requirement to keep the grain properly stored and dried? Don't you kind of have them between a rock and a hard place?
I see my time is up. May I answer that question, Your Honor?
Of course, because it was mine.
Yes, I figured as much. So the issue is a pragmatic one versus a legal one that fits in within the context of the UCC. The pragmatic issue is obviously it is going to be problematic for the senior creditor in that particular instance, as you've described, and they may have to figure out at that time how to address that with the producer. That does not, however, allow the third-party junior lien holder, Heartland here, to come in and simply by virtue of expressing that perhaps the producer would run into financial troubles, that the junior creditor who is on notice by virtue of our UCC1 and our direct notice to them, that does not allow the junior creditor to then engage in essentially the self-help remedy of helping itself secretly to the proceeds of the grain, notwithstanding its knowledge by virtue of the UCC1 of our prior security interest, and notwithstanding the fact that we provided a direct notice to them as a buyer. So as a pragmatic issue, that may create occasional problems between us and the producer. As a matter of UCC law, it cannot be used by the junior lien holder to then just engage in self-help consisting of unjust enrichment in this case.
Thank you.
Thank you.
Mr. Moorlach?
Thank you, Your Honor. Counsel for the bank used the word secretly twice, and in their briefing went overboard to paint Heartland and maybe any grain warehouse as operators in the dark, stealthily taking bank proceeds. Nothing could be farther from the truth. None of those kinds of allegations were listed or identified in the petition. The bank did attempt a motion for attorney fees based on the conduct of Heartland, but then withdrew that because there was no basis for attorney fees given the conduct here. And I didn't put this in the brief, but because of the nature of the briefing and because counsel, again, characterized Heartland's conduct as secretive, I'll tell you, and this was a conversation under Rule of Evidence 408, but before the suit was filed, Heartland and I were flummoxed by the claim, and we got everybody, officer from the bank and officers from Heartland, on the phone to explain that no, we weren't taking antecedent debt, laid out exactly how everything was done. And under the facts of this case, Heartland was absolutely transparent, especially given the knowledge.
Would you
that the
agree,
bank
though,
had.
that withholding the proceeds to cover the grain drying costs, isn't that in violation of the double jeopardy notice that they were sent upon the grain being delivered?
That notice, again, was sent in the context of an industry and a business in which antecedent debt would not be applied to that grain sales, but not the necessary costs of drying.
But it is in violation of the notice, correct? I mean, I understand your position that industry custom is in violation of the UCC, but this notice directed them specifically how to deal with the proceeds, and they didn't follow that notice. Is that right?
Again, Your Honor, respectfully, under that notice, the proceeds of the sale of grain were supposed to be sent to the lender, and that's what Heartland did, along with the settlement sheet, which reflected the offsets for drying and storage. So was it in breach of that notice? I'd still maintain that Heartland's position is that it would not be, given the way that those parties have always engaged in business for decades.
Was the settlement, is it a disputed fact whether the settlement sheet was sent to the bank as opposed to only to the producer?
There was no obligation for Heartland to send the settlement sheet. The settlement sheet is provided to the actual seller of the grain. If that seller happens to have a lender, it would be up to that lender to decide.
Well, what supports Heartland's position that the bank knew that these drying costs were being deducted, other than this general knowledge that that's the common practice?
It's actually specific knowledge that we provided in not one but two affidavits, and the record shows that the bank's affidavits only averred to the fact that they didn't get an express notice from Heartland about these offsets. But the bank never filed any kind of affidavit or supplied evidence that Heartland's characterization of the industry and practice was incorrect. And to answer your question, the bank gave its borrower authority to market their grain. The bank knew Heartland was a listed buyer for the grain. The bank provided Heartland a notice of its interest. Under the Duggan factors...
But none of those things go to actual notice. But I want to take you back to Justice McDonald's questions about, by seeking unjust enrichment, aren't you conceding that you don't have a claim under the UCC and that the bank does have the superior claim?
It has under Article 9, yeah, the bank has a prior lien secured interest.
And so you're asking,
but that's the Duggan exception.
Right, and so you're asking us to adopt the Duggan exception, which is a minority view and has been criticized. Is that right?
Well, it's certainly been criticized, and conversely, and I'm not. And forgive me, Your Honor, I'm not sure it's the minority view, but it is, I think, a great roadmap for understanding how unjust enrichment, which is not set aside by the UCC, in certain circumstances. And I think the circumstances of the case here are exactly the kind that require a look at that. With 8 seconds, I did want to say that we also believe the district court erred by applying the discovery rule to the statute of limitations, and that the 2-year statute should apply. Thank you for your time today.
Thank you very much, all counsel. The matter of MidWestOne Bank versus Heartland Co-op is hereby submitted, and we will adjourn court. Thank you.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.